Nous sommes très heureuses que vous avez décidé de passer votre samedi matin ici. Welcome to our public meeting on human rights in the Canadian mining sector. My name is Penelope Simons. I'm a professor of international human rights law here at the university, and I'm a co-organizer of this event along with my colleague, Professor Linda Collins, who is an environmental law lawyer. We have put together this a workshop and this public meeting to try and engage and develop a public debate on some of the issues about human rights and mining in the domestic sector. What sparked our interest is that the focus of much of the public debate has been on what the Canadian extractive industry has been doing abroad and its human rights and environmental impacts. And that has been reflected in the report, for example, of the Standing Committee on Foreign Affairs and International Trade, and then the roundtables on corporate social responsibility and the Canadian extractive sector in developing countries, and the ensuing advisory group report, and then the government's response last March. This dialogue that has been going on has been focusing on the policy imperative that Canadian corporations abroad should comply with the same standards in terms of human rights and the environment that they do when they are in Canada. So the implications is that the standards in Canada are high and that the industry is compliant with Canada's human rights obligations. So there's been comparatively little focus on what's actually happening in the domestic sector, and we wanted to question what was happening, to problematize that issue, and see to the extent to which human rights are actually protected in Canada in the context of mining activity. Canada has some of the highest mineral exploration activity in the world within its own borders, and Ontario itself produces 1/3 of Canada's mineral output. When we're talking about human rights here, we're talking about human rights writ large. So that would include Indigenous people's rights, so Aboriginal people's rights, environmental human rights, economic, social, and cultural rights, civil and political rights, etc. Now, I'd like to thank, first of all, our sponsors for allowing us to put on this public meeting. The Environmental Law Group here at the Faculty of Law has sponsored this event along with the Human Rights Research Center, Research and Education Center, the University of Ottawa, the Faculty of Law, the IUCN Academy of Environmental Law, and of course the Social Sciences and Humanities Research Council. I also want to thank a couple of people who have been instrumental in getting this organized, Jordana Laporte and Andrew Brown. And also we have a number of student rapporteurs who have been here both yesterday and today working very hard to take down what people are saying. So thank you very much, all of you. Now I want to just tell you a bit about the structure of the day before I introduce two people who are going to talk to you very briefly, just to give you an outline of some of the problems with the Ontario Mining Act, and then what we talked about yesterday. But what we're going to do today is to have a this day is about discussion. This is not about talking heads sitting here telling you things about mining. What we want to do is to divide you into groups and talk about specific questions. So once we've finished these introductions and the summary of what we talked about yesterday, we're going to put you into, divide you into two big groups and then into smaller groups to discuss two questions. So one side of the room will discuss one question and the other side will discuss the other question. Then we'll come back and report on that discussion and have a larger discussion. We'll then have a break, and again, you'll be divided into groups, and you'll be given, again, two different questions to discuss. And what we'd like to ask is that those of you who were participants in the workshop yesterday try and get each of you into a different group so that you can perhaps share some information that might be helpful to the discussion in the smaller groups. So I'd like to introduce two people who are going to be speaking to you briefly. First of all, Joseph Castrilli, who is counsel to the Canadian Environmental Law Association. He's a member of the Ontario and British Columbia Bar, and he's a specialist in environmental law. He has an LLB degree from Queen's University and an LLM degree in environmental and natural resources law. And he has been instrumental, brought some landmark cases before the Ontario Environmental Review Tribunal with respect to environmental law issues. He's also lectured at Queen's University, and he's done 3 major studies on orphaned and abandoned mines in Canada. Professor Linda Collins is an environmental law lawyer. She teaches and practices in the area of environmental law. She has an expertise in particular in toxic torts, and she's appeared before the Standing Committee, or the Standing Environment Committees at both the House of Commons and the Senate, and has testified in a public hearing at the European Parliament in Brussels. In addition, in 2008, she served as co-chair of the Province of Ontario's Toxic Reduction Scientific Expert Panel. So I'll pass you over now to Joseph Castrelli, who's going to give you an overview of the Ontario mining legislation.
Penelope and Linda for inviting me here this morning, and also for you folks for coming out on a Saturday morning to hear all this. Before I start, I just want to say that I'm indebted to Maureen Carter-Whitney from the Canadian Institute for Environmental Law and Policy for some of the comments you're going to hear this morning in connection with the Mining Act. The province of Ontario has had mining legislation since 1873, and historically the purpose of that legislation has been to facilitate the exploitation of natural resources. The 1906 version of that law introduced what is known as the free entry system, which was designed to encourage mining as a means of increasing settlement in frontier lands, a concept that more or less doesn't apply any longer. Free entry essentially meant 4 things: the right of prospectors to enter lands containing Crown-owned minerals and to undertake mineral exploration. Secondly, the right of prospectors to acquire mineral exploration rights by staking or claiming. Thirdly, the exclusive right of the claim holder to carry out further exploitation and exploration within the claim area. And finally, the right of a claim holder to obtain a mining lease to undertake mineral production. As you can imagine, over time, this kind of regime was a recipe for breeding land use conflict between mining interests on the one hand and Aboriginal, recreational, tourist, and environmental interests on the other. A couple of years ago, the province's environmental commissioner characterized this regime as a century-old system that relies on principles that do not reflect modern planning or resource management. And even more recently than that, the courts in Ontario, in recent litigation involving mining companies and First Nations, have questioned the existing approach to mineral exploration and development that's embodied in the Mining Act itself. These and other criticisms eventually led the Ontario legislature to enact amendments to the Mining Act in 2009. And the new Mining Act, which will come into force when regulations are promulgated probably in 2010, now has as its purpose the following: to encourage prospecting, staking, exploration for the development of mineral resources in a manner consistent with the recognition and affirmation of existing Aboriginal and treaty rights, including the duty to consult, which is a constitutional obligation, and to minimize the impact of these activities on public health, safety, and the environment. It may sound better, but it ain't necessarily so. The new law makes numerous amendments to the existing law relating to things like prospecting, prospecting for land, staking, and disputing mineral claims between owners of surface rights, as well as exploration work and consultation with Aboriginal communities. However, the 4 characterizations of the free entry system that I mentioned at the opening of my remarks remain largely intact, with some modifications. Under the new Act, for example, certain exploration activities will require consultation with Aboriginal communities. Depending on the nature of the activity, the person may have to submit what is known as either an exploration plan or an exploration permit. At this point in time, we do not know the content of those obligations and therefore those activities, and therefore which of those activities will be subject to either the plan or the permit requirements. There is now, or there will be when the law comes into force, a dispute resolution process established for particularly Aboriginal communities. In southern Ontario, lands for which there is a surface rights owner and the mineral rights belong to the Crown will be deemed to be withdrawn from prospecting, staking, sale, and lease. In northern Ontario, such lands may be withdrawn by ministerial order, but in both cases, pre-existing rights are not affected and applications may be made to reopen such lands. There are a number of other matters that have been amended in the new law, which, given the request of the conference organizers that I be brief this morning, I will not burden you with at this point in time. Overall, there will be somewhat more transparency and participation under the new act, but not as much as you would like to see in a statute that had largely been unchanged for over 100 years. And finally, with respect to Aboriginal communities, they will still confront mining projects for which there is no obligatory joint decision-making, revenue sharing, or consent process. And I guess subject to any questions you might have, those are my submissions.
Okay, my job is just to briefly summarize some of the issues that we discussed yesterday in the kind of gathering of experts. And the next two slides simply remind us of the various panels that were held yesterday, but I'm going to try to kind of synthesize the analysis from yesterday for those of you who weren't here and just to get us thinking for today. So as Penelope said, the idea of this public meeting and yesterday's symposium was to basically measure Canada's domestic performance in mining against our international human rights obligations. So it's a bit of a little interesting project. Typically we measure domestic performance against domestic law because very often we're interested in suing or defending lawsuits. And so we're assessing kind of compliance with domestic environmental regulation, et cetera. And when we think about international law, we're often thinking about Canadian behavior overseas. But we wanted to do this somewhat new thing and measure Canadian performance against international human rights obligations. So right off the bat, we have to think about what kinds of rights are we talking about. And as Penelope said, there's a category of sort of the more traditional rights that many of us are familiar with, the civil and political rights. And, you know, in Canada, we haven't seen a lot of the very blatant human rights abuses in terms of forced displacement, although we have seen levels of contamination that amount to forced displacement or that result in intolerable living conditions in communities surrounding mines. In terms of economic, social, and cultural rights, obviously the right to health, the right to culture can very much be implicated when we have mines that create pollution and contaminate culturally significant lands or lands that are used for subsistence activities, for example. And then in the realm of environmental human rights, not only is there the right to environmental quality that can be very seriously undermined by mining activities, but there are also these procedural environmental rights that involve what we call environmental democracy, the right of people to get involved in environmental decisions that really affect their lives. And we heard from the speakers that there are concerns on all of these fronts with Ontario's Mining Act and mining regimes more generally in Canada. So environmentally, certainly the mining regimes permit very serious contamination. We heard about one of the most topical issues right now, which is this exemption basically from the Fisheries Act that is allowing lakes and rivers to be now turned into toxic waste dumps from mines. And in terms of procedural rights, there is a widespread concern that Ontario's Mining Act, although it has improved with the new amendments, doesn't really allow people to become involved until late enough in the process that very often the project is going to go ahead. So we're not having really front-end public engagement about how we want to use land and whether or not there should be a mine at all. It ends up that a lot of the consultation happens really further along in the process so that we're talking about how and how could we mitigate, et cetera, details. Those are some of the major concerns that were raised yesterday. participants in yesterday's symposium are here today and will be with you in your breakout groups and can answer other questions and reflect more of the discussion from yesterday.
So now we'd like you to do, we'd sort of like to break up the audience into groups. So say from Karen Keenan that way, you could look at question 2, and if you would sort of get yourselves into smaller groups of say 4 or 5, that would be helpful. And this side, you could look at question 1. So the questions are, how can mining legislation achieve reconciliation between Aboriginal peoples and the rest of Canada? And the second question is, looking at participatory rights in the mining process. What should they be? Where should we be able to, as individuals, be able to engage in decision-making about mining activity in Canada? So, and when in that process should it kick in? Should it kick in when we go at the exploration stage, or do we want to be having some sort of input earlier on when claims are staked, etc.? So those are the 2 questions. So if the facilitators could help the people get into groups, that would be great. Rapporteurs. So we'd like to start with the reporting back process. So maybe a member from each of the groups could come up to the microphone and just tell us a little bit about what you talked about, and then we will have a larger discussion.
Well, there are a number of recommendations that we came up with. In no particular order, we discussed the possibility of having Aboriginal consultation in the drafting of the regulations on equal footing, not just as a sort of, you know.
So we're talking about the mining regulations.
The mining regulations themselves, including the regulations that may lead to any dispute resolution processes. Because if the dispute resolution process itself is just made by the minister without any consultation, that's not a meaningful forum to have an airing of grievances.
That is a great idea. So we're now talking about, for those of you that aren't that familiar with what's happening with the Mining Act, the new Mining Act has been passed, but the regulations haven't been passed, and a lot of crucial details have been left to the regs, which often happens in environmental statutes. So one of the things that's been left is there's going to be a dispute resolution process for disputes with Aboriginal communities, but we don't know what it's going to look like. And what a fabulous idea, rather than, you know, guessing or hoping for the best, to collaboratively develop that process. I think we can realistically think it will go better if it's designed cooperatively. Great idea.
It wasn't mine. In terms of reforming the legislation itself, we thought that one helpful amendment would be to add something, perhaps in the interpretation section of the legislation, some kind of conception, the Aboriginal conception of land and how they understand the land and their relationship to the land, and so that could be one way of adapting Aboriginal concerns to the interpretation of the Act itself. So that's another practical suggestion.
Another great idea.
A lot of environmental groups are increasingly working with Aboriginal groups as well, and so there was one suggestion of possibly increasing the availability of standing for environmental groups, may improve access to justice. And one, we're not sure how practical or realistic this was, but possibly giving staking priority to Aboriginal groups. The free entry system right now is kind of a free-for-all. It often prioritizes industry, and so if there are Aboriginal groups that had some sort of like first crack at the systems, they could have first right of refusal maybe on the staking.
Can I ask a question of the mining experts regarding that? Can you stake a claim just to protect it from ever being explored?
No.
No.
No?
No. It's against the law to stake for anything other than mineral.
Okay. Good to know.
And I think those were many of the suggestions we came up with. I don't know if anybody has anything to add. Sorry?
Environmental assessment.
Yeah, environmental assessment for mining. That'd be something that we needed. Yeah.
Okay. Thank you. Next group, Maureen's group. Thank you.
We had a really interesting and wide-ranging discussion. I wouldn't say we came up with any kind of consensus at all on the question, other than maybe some questions about the question. But so I'll just give you a rundown on some of the things that were said. People were interested in the issue of whether it's possible to achieve reconciliation through legislation, if that's even a possibility, particularly through Ontario's new Mining Act, or even if it had been better amended. There were concerns about the overall issue of equality around land use planning, like not just in terms of Aboriginal peoples, but other communities that also that have do not have the ability to make land use planning decisions in their communities vis-a-vis the mining companies. The point was made that one of the important things about the reconciliation between Aboriginal peoples and the rest of Canada is to redress historic imbalances. Also raised was the institutional imbalance between industry and other people with rights to land. The need for greater political accountability for decision makers was raised in the context of this question. The notion of free, informed prior consent was emphasized. Someone made the point that there's a need to link domestic legislation to international instruments, such as the Declaration on the Rights of Indigenous Peoples. And someone also made the interesting point that there's a bit of a mismatch of jurisdiction in Canada, whereas the federal government has the primary relationship with Aboriginal communities, but it's provincial legislation that regulates mining. So, thanks.
Great. Thank you. Next group.
Basically, we looked at the various stages of the environmental assessments and how they're done in screening and scoping the projects proposed by the investors. And one of the various issues that were raised was giving the people the opportunity to intervene at an early stage during these proceedings, which we saw is not the case under the present legislation. Then we also discussed a little bit about the participation and the role of the Auditor General's office, for which we had the privilege of listening one of our group members coming in his personal capacity from the Auditor General's office. One of the other issues is when do you actually begin talking to the public? At what stage of the process? And we discussed and saw that this usually happens once the deal has been done, and the public usually gets to comment and to intervene once the industry and the government has already decided about how the project is going to proceed. So we expressed our concern on this matter, and we think that the environmental assessment should not be a rubber stamp for done deals. On the other side, there was an interesting question raised in terms of the overlap between federal and provincial legislation in environmental assessing, and the different requirements under these two layers of governance. Finally, we discussed briefly that awareness and funding from the projects as an idea should be provided by the investors to actually allow the public to have independent or advised legal information on participating in these procedures. We can see that many of these projects are very technical and complicated, and the environmental assessments are not accessible to the lay person. So as an idea was to create a fund from the project itself to go to public participation. And at the end, we spoke briefly about the purposes of legislation and how some of the very preambles of the acts should be changed with respect to encouraging Aboriginal and other participation.
Great, thank you very much. Amy?
Linda chuckled because I learned an important lesson about consultative processes and participation this morning. If you don't stick with it, I mean, if you drift off and kind of lose your focus and go for a muffin, you can end up with a decision that is adverse to your interests. And that is why I'm here reporting on our conversation. Utterly, I think, without recommendations, but with perhaps a range of plausible insights. First of all, we identified a distinctive issue in the mining sector, that indeed the mining sector is a range of activity that involves multiple phases, each of which might reasonably engage participation, from exploration, development, environmental assessment, permitting, ultimately running through to questions around decommissioning. We also benefited from an insight about a kind of corporate discontinuity in what we might be calling the mining sector, that those active in the exploration phase will not necessarily be the same entities who are involved in subsequent stages. We noted that even within Ontario there are regional variations in terms of the foundations of land use planning. Southern Ontario has a planning base. The far north is now anticipating new legislation that will alter land use planning in a fundamental way up there. Perhaps the long-term search would be for something called best practices. We talked about the nature of the consultation process, and I will just flag 3 sub-elements of that. Questions around the content of information that is available in the process of consultation. What is the quality of that information? How complete is that information? Secondly, there were issues around who represents whom in participatory processes. What is the status of community or municipality in participation? And thirdly, there was an emphasis on the importance of having some kind of feedback, response in terms of reasons, accountability for the way in which participation contributed to an ultimate decision. We also noted, just as a kind of a minor, not necessarily a minor, but an alternative perspective on some of these questions, that in fact we're not always talking about mining development as a new activity in a virgin or unutilized area. There are many parts of this jurisdiction and others where existing communities have been established and are currently dependent on mining activity and will have distinctive interests in the manner in which subsequent phases or new developments proceed. And then simply as a general comment, opportunities for participation exist completely outside the framework of mining legislation. And perhaps an often overlooked example is the fact that most of us either have or potentially will have pension fund or long-term retirement income interests in businesses that are active in the mining sector, and so we have other ways of articulating our concerns to those bodies. Thank you.
I'm going to boil down what was a very extensive set of comments by a very able group into 3 points, 2 points of which I'm sure occurred, 1 point of which it's possible I dreamt occurred. but I think it's consistent with what I think the drift of the conversation generally was about. The first one is one ought to apply the Environmental Bill of Rights to approvals issued under the Mining Act, both with respect to notice and comment and also third-party appeals. Secondly, one ought to apply individual environmental assessment requirements to mining. And thirdly, this is the one that I suspect I dreamt and may not have been as fulsomely discussed as I'd like to think it was, the need for funding in order to participate in these processes, which in short form is the same thing as saying bring back intervenor funding, please.
Joe, maybe you could just expand a bit on the environmental assessment for mining, because people might not know that that's an issue.
Generally speaking, there has been some discussion. I gather there's been, I wouldn't call it a commitment, but at least the subject of applying environmental assessment to mining projects as a result of these new amendments has been discussed during the course of the debate on the bill itself. And when I use the term individual environmental assessment, what I mean by that is a full-blown social, environmental, economic, and cultural impact assessment with respect to each mine, either new or expanded, as opposed to a sort of class environmental assessment approach, which is now what often happens under the environmental assessment process in this province, where one single environmental assessment is done just once, and then what are more in the nature of fairly thin versions of that are applied to individual mines thereafter. The class approach, in my experience, has not been a happy example of success under environmental assessment. The only way you really get down to the nub of whether a project is a good or a bad idea or not is to actually evaluate it under the full-blown regime that everyone contemplated would be applied when the Environmental Assessment Act was first passed in 1976, but was drastically shrunk in 1996.
All right, if those are all our reports back, then we're going to throw this open for a free-for-all discussion. Those of you who didn't get to report back that have additional comments, if you want to respond to comments that were made, if you have questions, there's an incredible concentration of expertise in diverse areas touching on these issues in this room. So, please come to the microphone when you have your comment or question. That's just because have you mentioned that we're videotaping today? We're videotaping today's session. If that's an issue for anyone, you should speak to one of us. Yeah, so please come on up to the microphones, don't be shy. You can feel free also to broaden, your comments to anything vaguely relating to the stuff we talked about.
In general, the thrust here seems to be how do we get a proper review of mining actions going on in Canada? And I guess what I would say is, having been involved in looking at mining acts, mining regulations, mining practices for a couple of decades, and having participated very extensively in all of the processes that were available to the public, I would comment that there is far too much focus on process. The processes by themselves very quickly become impediments to meaningful debate. What they do is they bring in a certain class of people who have the ability to participate in those processes. What I notice as well, even in the questions, is the questions drive this towards process. What are the next steps? How does one do? This doesn't work when the whole system fails. And the system fails at the level of developing legislation, of developing regulations, developing the practices and policies under which those regulations are applied. What one really needs is a much broader engagement, I'm convinced, of the full public, to realize the breach of trust issues that are involved in the way governments behave towards their fiduciary responsibility towards citizens. And I would argue that what that really needs is a look at a much broader level, far away from the narrow legal constraints of matters of principle. What are the fundamental principles we want to uphold? and then look at how those principles get translated subsequently into legislation and regulations and procedures. Arguing for special place for someone at some table at some secondary or tertiary stage of the process doesn't resolve the fundamental principle problems. And the fundamental principle is reflected, as Mr. Castrilli said, in the Ontario legislation, in the purpose statement. And the purpose statement says the purpose of the legislation is to encourage prospecting, staking, and development of mines. That's the game. And so if that's the game, then you're only commenting on how you implement that policy of pursuing the prospecting, staking, and development of mines, not putting it into a broader social, environmental, political context. And while I participated extensively in the review of the Ontario legislation, in fact, I submitted 300 pages of submissions on the Act, some of which resulted in 100 amendments being proposed at the committee stage, the clause-by-clause analysis stage. And what the Liberals did is they actually closed down the committee discussion after 3 amendments were presented. They weren't even debated. The other 97 weren't even considered. So what one has to do is step out of a flawed process and get it back to a broader public discussion, I'm convinced, at the level of principle. What are we trying to achieve? Where does mining fit? How does it fit with the whole broad policy, economic, social, environmental, and other interests? And fractioning it into little pieces where particular persons or groups or those with particular skills can become involved in the process, I would argue merely reinforces the ability of governments with mining companies to impose legislation that none of the citizens of the country would really want or ever tolerate if they knew what was actually going on. So I would really encourage you to broaden from this, to move up a level, to move the lawyers out of the process, to move the environmental legislation out, and move to the level of principles. What are we trying to achieve, and how does the system result in the breach of trust, the lack of due fiduciary care, the lack of proper respect of rights that are much more fundamental than apply to any narrow group?
I think this is a really interesting point, and it's a point that comes up very frequently in the context of Aboriginal consultations. So Gordon Christie has written this, I think, very helpful analogy. He talks about the fact that in the Section 35 constitutional consultation context with Aboriginal peoples, it's not the Crown going to Aboriginal peoples and saying, what do you think we should do with this land? What are appropriate uses and behaviors on this land? It's always the Crown has a vision. We want to mine, we want to log, whatever, and goes to an Aboriginal community and says, you know, how do you feel about this? How can we accomplish this together, right? And Professor Christie says, you know, imagine somebody breaks into your house and invades it and occupies it and says, now we'd like to know your opinions about how we use your living room. So I think it's a funny thing with participatory rights, because I've done some work in places in the world that don't have participatory rights, and when you spend time in places that don't have them, you realize how incredibly fortunate we are to have them here. They're crucial, but there is always the danger of being led around by the nose. You know, there is the danger that we spend time in processes that aren't guaranteed to produce any kind of particular outcome. And just to throw out, you know, one idea, I think in fact the purpose of this meeting and yesterday's symposium is to come back to the level of principle. And we chose to use a human rights lens to do that. But Dr. Joe Thornton and I and others have actually suggested that the only truly non-derogable law, the law that really can't be broken, is natural law. You know, the empirical descriptive laws of ecology, those laws really cannot be broken. They always hold true. And so some of us have suggested that we should try to match up human-made law with ecological law, and the most non-derogable human-made law is the Constitution. So that maybe it makes sense to enshrine some of these environmental protections in the Constitution so that every other form of law that is subordinate to the Constitution would have to comply.
I would argue that what you're doing again is driving it back to law rather than to principle. And I think you have to move away from the focus of how do we put it in the statutes and get a discussion among people of what are those principles that we want to hold our legislatures and our bureaucrats to account to. And I think those involved in the legal community, unfortunately, because of their training, have a real focus on trying to do it through statutes. And I would argue that the statutory and regulatory process is one that mitigates against fundamental justice. And by bringing merely those with the qualifications to speak to the table, it actually prevents the real issues from being heard. we get locked into a new mechanism here and there, and never focus on the big issues.
Thoughts, other thoughts on this point or other points? Questions, comments, queries, observations?
Take this maybe in a little bit of different direction. Something we discussed yesterday, that part of the problem with consultations, and you've certainly just given us a great analogy of the person breaking into your house and then consulting with you about how they're going to use your stuff. Part of the problem with consultations is that there isn't an option at the end of most consultations for community to say no, right? So it's the free, prior, and informed consent. And that word gets thrown around a lot, and I think, you know, one of the reasons it's so critical is because whether or not a community says no, it changes the entire nature and tenor of the consultation when a community could possibly say no. In other words, when you could kick the person out of your house instead of discussing how they're going to use your stuff. So I still think we need to keep that no option, and not just for Aboriginal communities, but for all communities.
Just to follow up on Charles, if folks are interested in a process that was trying to do what Charles was talking about, you might want to look at what they've been doing in Nova Scotia, because they did actually start with a sort of province-wide process of having roundtables and discussions around what do people want, how do they want to manage their natural resources. And the fruit of that remains to be seen because it's still in the process. But I think it was an interesting example of a government actually trying to do that. We'll see how effective it was. When I read your two questions, I kind of thought they were largely the same, or the answers would probably be largely the same, because I think, building on what Catherine just said, if communities are going to be reconciled, they need to be able to have input right at the very early stage. And I think one of my biggest fears with mining right now in Canada, and maybe this is because I'm too wrapped up in a very specific project, is that we have the potential to really backtrack on reconciliation. And I'm not talking about legal reconciliation, I'm talking about cultural reconciliation and learning to live together on this continent. We're seeing mining projects being promoted against the will of Aboriginal communities. The mining companies are able to promote the jobs, economy in rural areas that are hurting right now. And so people get expectations and they get excited about the prospect of a mine going in, and then an Aboriginal community may or may not step in and say, well, geez, we weren't so keen on that project, we don't think it should go ahead. And we're seeing this right now in British Columbia, creating huge tensions and racism flaring and providing an opportunity for an incredible backwards direction in terms of finding a way to live together. So I think we need to find ways where those kinds of projects don't move forward to the stage where companies are able to promise great things to local communities absent of Aboriginal consent.
Definitely, I agree with your point. I think, look, the principles are very important. But in the end of the day, we need to translate these principles in procedures, in regulation. If not, we in fact don't have a way to enforce that. And in my view, have a lot of space for, like, a university, like Ottawa University, to do studies, to do research. What are, for example, the good experience? What are the lessons that we can learn from what's happened in Canada, but also outside, and how we can improve our regulation? I remember last year I was working in one country, East Timor, and one moment I was helped the government to write environment impact assessment law. And one of the issues I had was about consultation. As much I have all the principles in my mind, I know what a good consultation means and what a bad consultation means. How I translate that to the regulation is a challenge. And we need to admit that and be engaged, proactive to bring solutions and bring the lessons, the negative and the positive lessons, to our regulation. Thank you.
Thank you.
If I'd like to make one more comment. Regulations, policies, and procedures follow the legislation. And one has consultation all the way through. There's a hierarchy here. I'd actually like to quote from Ontario Mining Act, a section, which indicates the depth of the problem and the inability to get the sequence right. If you have consultation under a bad statute, you get nowhere. I won't read the whole piece, but it's section 175. What it says is, in that section, it deals with actual mining, not the exploration phase, and it says a mining company, if it finds it convenient to the development of the mine, can go to the Mining Lands Commissioner and ask for permission to do anything he wants on any land and any water. And one of the provisions, there are I think 10 of them there, this section was strengthened incidentally under the recent bill, added an additional subsection and reinforced some of the other sections, giving rights to different classes of mining interests. But one of the rights they can seek and get by an application to the Mining Lands Commissioner is the right to deposit tailings, slimes, or other waste products upon any land or to discharge the same into any water. That's there in the Act. If you've got that in the Act, consultation under how they get to deposit their waste, slimes, and tailings onto any land or into any water becomes kind of a meaningless exercise. And what I would argue is we need to really get the legislation right. So that I'm arguing for a discussion at principle, not at the level of the detailed discussion. Of course those will go on. But if you want to avoid wasting time in non-productive discussions, as I would argue many people did in trying to input into the legislation, Bill 173 under the Ontario, because it was a predetermined process, you have to up the level of discussion at the very beginning, pre-legislation, into fundamental principles. That's where people can understand. Because I think almost everyone knows that it's absurd that a mining company, if it's convenient, can get the right to deposit tailings, slimes, or other waste products upon any land or into any water. And subsequent discussion becomes meaningless when this is what our legislatures and legislators approve.
That's actually a very helpful segue into our next section, because you'll notice that after the break, we're going to talk about whether there should be an environmental human rights bottom line in this kind of legislation. So substantive limitations on what kinds of impacts we're willing to tolerate, and then a specific case study on that question, and the question of whether we should be allowing uranium exploration at all. But first, there's some time for refreshments. What is it, about 10 minutes?